So I think we have everybody here now. We're ready to go with the oral argument in the case of Jeffrey Burdinsky versus Branch Banking and Trust Company. This is an oral argument session with the 5th District Court of Appeal. My name is Rand Wallace. Also on our panel today, we have Judge Eric Eisnagel from Seminole County and Judge Dan Traver from Orange County. I'm going to assume that the appellant wants 5 minutes for rebuttal unless you tell me differently. And I'm assuming we have for the appellee, which counsel is appearing.
I think her microphone's off.
Yeah, and Ms. Rios, I think your microphone is off. So
I think I got it. I apologize. Shaib Rios on behalf of the appellee.
Okay, no problem. All right, so Mr. Bowen, you may proceed.
Thank you, Your Honor. As the briefs reflect, this appeal involves a VA mortgage and specifically BB&T's failure to comply with pre-suit notice requirements required by the VA regulations. It implicates this court's prior ruling in DeLong, which I believe, Your Honor, Wallace was a party was a per curiam opinion, which found that where these VA regulations are incorporated into a mortgage, they are in fact conditions preceding the foreclosure, and a bank's failure to comply with those pre-suit disclosures precludes foreclosure and requires a dismissal of the case. I don't think there's any dispute.
Counsel, the bank seems to argue that, or at minimum implies in their brief that DeLong was wrongly decided. Do you have any thoughts on that?
Well, I disagree with them. I think DeLong doesn't just stand on itself. To hold that DeLong was wrong, you'd have to hold that a series of other cases were wrong as well. DeLong refers to a Palma case, which again, I believe Judge Wallace might have, wrote. And that involved HUD regulations, and that court definitively found that where in a HUD an FHA mortgage, where you include or incorporate those regulations into the mortgage, they, by the party's own agreement, had become a condition preceding to the foreclosure action. And so failure to comply with those HUD regulations, which are very, very similar to the VA regulations and the notice requirements, and some of the other requirements that they have. And the court in Palma said where you don't comply with those, it requires a dismissal of the foreclosure action. So I think DeLong is in line, not with just, common sense, where the parties have agreed to incorporate certain terms into their mortgage. It goes along with prior precedent from Palma as well. So any kind of reversal of that would require to reverse Palma, I believe, as well. And I think, going back to the reasoning, it just makes sense that I know what the bank argues is that the regulations in and of themselves don't provide a defense for the homeowner. That may be well and true. And there are some cases from the past that held that, for example, FHA regulations aren't conditions precedent, but those cases didn't deal with mortgages that specifically incorporate those regulations. And that's kind of critical here, because the parties are allowed to agree to any conditions precedent they want. They chose to incorporate. In fact, the bank chose to incorporate these VA regulations into the mortgage. If they didn't bind the bank, they didn't apply as conditions precedent, that just including in there would be superfluous. What was the purpose of including them in there? So I think it's clear that where you've included that, and I think it's clear in this mortgage. I mean, I cited several provisions in the brief, we can go back to it, but it's clear that they incorporated the VA regulations into this mortgage. And it states in there that it incorporates the liabilities and obligations under those regulations. The bank's liability under there is to send these pre-suit notices. The borrower's right is to have that pre-suit notice, and they didn't comply with it. And again, there's no dispute that they didn't comply with it. So I think based on DeLong, this court doesn't have a choice but to dismiss this foreclosure action.
Okay. And counsel for the appellee, Ms. Rios.
Yes, good morning. May it please the court. Shaib Rios on behalf of BB&T. BB&T is asking this court to affirm the final judgment that was entered at the trial court. And BB&T is suggesting that an affirmance will not run afoul of this court's prior rulings in DeLong or in Palma. And BB&T is aware that it has an uphill battle, not only before this court, but in particular this panel, based upon the decisions in Palma and DeLong. And so if there's no specific questions, I'd like to start with some of the distinguishing factors and why BB&T believes that an affirmance would not run afoul of those prior decisions. And at the outset, the court asked basically whether BB&T thought DeLong was improperly decided, and BB&T does not believe that DeLong was improperly decided. So we start off with this court's decision in Diaz, which basically indicated that, or rather, it started to discuss whether or not federal regulations incorporated into loan documents need to be complied with. The Diaz decision, however, involved, or rather the loan involved loan documents that did not specifically reference or incorporate any regulations. And so Diaz was decided not in favor of the borrower, but it was based upon essentially the fact that the borrower had not met its burden to demonstrate that there were federal regulations or conditions precedent that applied. So now we move to Palma. And in the Palma case, this court referenced the fact that at the time that it was deciding that case, there was no appellate court decision that had at that point determined that HUD regulations, which were the regulations at issue in that case, specifically 203604, whether those would be a condition precedent to filing a foreclosure. And the court reasoned that the reference to the HUD regulations essentially incorporated any requirements that HUD mandated. This is one of the first differences, because if you take a look at section 203604, the specific HUD regulation that was at issue in Palma, there is very specific language. So it discusses the face-to-face requirement that the mortgagees must comply with. And there are certain conditions, but specifically in the regulation, it specifies that it must be complied with, and I quote, before foreclosure is commenced. I don't think there could be any disagreement that it was the explicit intent for this regulation to create a condition precedent to a mortgagee commencing a foreclosure action.
Talking about the HUD regulation. Counsel,
for the HUD.
Okay.
Yes, for the HUD regulation. So distinguish that with the VA regulation that is at issue in this case. If you take a look at the specific language of the VA regulation, and as discussed more thoroughly in BB&T's answer brief, we go through a lot of the federal cases that essentially suggest that the VA regulations are really there to protect the VA. The VA is guaranteeing to a certain extent the underlying loan, and the regulations are there and in place to protect the VA, not the borrower. For example, there is the Baczynski case, which is actually a Veterans Administration appeal, where they essentially talk about a mortgagee's failure to perform pursuant to the regulations, while it may result in some type of sanction in the form of a partial or total loss of the guarantee, it does not create. Yes.
You say that the regulations are in place to protect the VA and not the borrower, but the actions and the activities that are required to be completed by the bank, the intention, at least initially, is to assist or give time for the borrower to come current with the loan, which means it doesn't go the further step of requiring the VA to make good on the loan to the bank, correct?
That is absolutely correct, and the bank would agree with that assessment. I think then the issue, though, is if you take a look at the entire section, which is at issue here, there is no mention of a condition precedent. There is nothing indicating explicitly, or the bank would contend implicitly, that—
Counsel, it really sounds like you're arguing that DeLong was wrongly decided. Why don't you cut to the issue and tell us, if you're not arguing that DeLong was wrongly decided, tell us how to distinguish it from this case.
Sure. Well, because first of all, DeLong essentially extends Palma by stating that the VA regulations incorporated into loan documents, basically, let's say any conditions precedent, right, would be incorporated into those loan documents, similar to HUD. So the first distinguishing factor is the same as PAMA. The HUD regulation explicitly creates a condition precedent. The VA regulation here does not. So DeLong, to the extent that it simply says the VA incorporation of the VA regulations into the loan documents means that any requirements or conditions precedent that are referenced therein would be applicable, is fine. The BB&T takes no issue with that. The issue is that the VA regulation doesn't in fact contain the condition precedent language. The other issue, and I think this is important to get to the other distinguishing factor.
Isn't it contrary to DeLong's holding, counsel? I mean, how is that not? Go ahead.
Because DeLong was specifically decided because there was absolutely no compliance whatsoever. In DeLong, the bank at trial attempted to
now
introduce
it sounds like you're making a substantial compliance argument.
That's going to be the next, yes, that's essentially where I was going.
It sounds like you've already jumped to the second argument, which is substantial compliance. I thought we were still talking about whether DeLong was distinguishable.
Well, I think DeLong is distinguishable because they never got really, this court never got to the substance of the letter, right? It simply was saying that VA regulations referenced in loan documents would be incorporated into the loan documents. The bank's position is that the VA regulations concede incorporated into the loan documents, but the regulation, specific regulation at issue, does not create a condition precedent, which is dissimilar to the HUD regulation in PAMA. So,
except for DeLong dealt with the VA regulations at issue here, correct? Or are we missing that?
It did, yes. It essentially stated that the court actually said there's
the same regulations, yes or no?
I'm sorry?
Did DeLong deal with the same VA regulations, yes or no?
Yes. Yes.
Okay. If it's the same exact regulations, and in DeLong we said that those amounted to a condition precedent, then how do we not have a condition precedent here unless DeLong was wrongly decided?
I guess my interpretation of DeLong was essentially that it was stating that to the extent VA regulations or the VA was referenced in loan documents, it would be treated the same as the HUD regulations incorporated into loan documents, which is what PAMA said.
But DeLong went further than that, right? It took the additional step of actually holding that the bank did not comply with a condition precedent that was contained in the VA regulations, correct?
That is correct. And to the extent that this section was the one at issue and it was determined that this section was a condition precedent, I guess, yes, the bank would be suggesting that that was an error.
So, okay, so you are making an argument, at least in some sense, that DeLong was wrongly decided? Yes or no?
Yes. And
right.
And specifically,
go ahead.
I apologize. And specifically, I mean, you know, DeLong, the two quotes that I have here are essentially the court says, there's no apparent meaningful reason here to treat compliance with VA regulations incorporated into the instant note and mortgage any differently than the required compliance with HUD regulations. But again, that language doesn't state VA conditions precedent. It says VA regulations should be incorporated or treated just as the HUD regulations incorporated. The nuance, I suppose, is that the VA regulations do not create a condition precedent. And then DeLong goes on to indicate essentially that the only reason it was compelled to involuntarily dismiss was because there was zero evidence of the letter. But again, I don't want to jump ahead because that does go into the substantial compliance.
That's
argument.
the substantial compliance argument, right? So you agree, do you agree that DeLong held that these VA regulations at issue here create a condition precedent? Yes or no?
No.
Okay, why not?
I believe that DeLong states that the VA regulations are incorporated into the mortgage.
So in your view, DeLong did not hold that these same VA regulations actually create a condition precedent. Isn't that why we reversed in DeLong? Or wasn't that the issue taken up in DeLong?
No, the issue in DeLong, and actually the quote is, this court has held, based on the lack of any evidence that Lakeview complied with this condition precedent, so I guess it does determine that it is a condition precedent, we are compelled to reverse the final judgment and remand with instructions to enter final judgment.
So doesn't that eliminate your first argument here? Substantial compliance is your second argument, right?
Yes.
Shouldn't that be the issue that we're talking about instead of the first issue, which is that there's no condition precedent at all? Because DeLong's already decided that.
Yes, I mean, to the extent that DeLong decided that this specific VA regulation created a condition precedent or was or is a condition precedent, then yes, that means that the bank's argument would fail. And the next issue would be, notwithstanding that, we would move to whether the letter that was sent was substantially compliant, which I believe is the standard that should be applied.
That seems like maybe it's your better argument of so far. Why don't you talk to us about substantial compliance?
Sure. So in the reply brief, Mr. Burdinsky essentially states that substantial compliance should not be the standard that is applied because this is a statutory condition precedent. But for the reasons, discussed previously, the bank does not agree with that and would incorporate some of the same arguments regarding the fact that the VA regulation doesn't explicitly contain language that creates a condition precedent. For example, in contrast to the StressCon case, which is what was cited in the reply brief, there is a specific Florida statute that indicates what needs to happen, a precondition before a lawsuit can be filed. More importantly, this court in Palma, DeLong citing to Palma, indicated that the condition precedent in HUD, and to the extent that this VA regulation is going to be a condition precedent, it would be treated similar to the paragraph 22 condition precedent contained within the mortgage. And it cites to Cologne and Samaru essentially for that position. So this court has essentially advised in DeLong that a substantially compliant letter would a substantial compliance would be the standard, and that a letter that is found to be substantially compliant would be sufficient. There's no need to prove technical deficiencies. And again, the bank concedes, as it did at trial and as it does again within the briefs and now at oral argument, the letter that was sent, which was admitted as Exhibit 5 at trial, does not contain any reference to the VA specifically. But if you take a look at the letter and its substance, it touches upon all of the, with the exception of the two, reference to the VA requirements, the language indicating, for example, that the borrower might not be eligible for future VA loans, that type stuff. But it does.
Counsel, why isn't that significant?
Well, it's not significant in this case because if we apply a substantial compliance standard, right, the first issue is the facts of this case. The testimony that the borrower gave at trial was that he did not receive the letter. So the bank's contention essentially is that any technical deficiency in this letter was not the proximate cause of him not being aware of what his rights or responsibilities were. He states that he did not receive the letter. The trial court made a factual finding that the bank properly sent the letter. So given what the defense was at trial, that the letter was not received, a technical deficiency would not have cured that. The bank could have sent a word for word letter reciting the regulation, and he didn't receive it.
Counsel, what if the bank had sent, instead of the various HUD disclosures and things of that nature that were sent, what if the bank had simply sent a blank piece of paper to him, but he claimed at trial that he never received it? Would you still argue that that was substantial compliance simply because he didn't receive the blank piece of paper?
No, because that wouldn't have any of the other information that was in fact contained in this.
What if the blank piece of paper had one paragraph that included one disclosure that HUD requires, but just one? And then he said at trial that he never received that disclosure. Would that be substantial compliance?
No, but I think that would be different than the letter.
Compliance, shouldn't we look at what information the bank actually sent?
Sure.
So let's talk about that.
Yes.
You can see that the bank never even attempted to notify the appellant that he would be ineligible for future VA loan guarantees, correct?
Correct. And I think that goes to the prejudice argument, right? It's not as though the borrower testified that he applied for and was declined for a VA loan. That there's no prejudice with the non-compliance or a deficiency with that technical requirement. The letter, again, provides phone numbers, websites, the different loss mitigation opportunities.
That's the VA though, right? I mean, none of those phone numbers were to a VA helpline.
That's correct.
And you know, ideally, or the law requires, those regulations require that you notify the appellant that not only will he not be eligible for future VA home loan guarantees, but that that he can call the VA to seek assistance with workout options, special payment arrangements that will reinstate your loan, and also the potential for repayment plans or loan modifications. And specifically notifying him that he can call the VA to discuss those options, correct?
That's correct. And the bank's position is that he was advised of all of those potential options and just advised to call BB&T and or HUD. But you are correct. There is zero reference to the VA, no website and no phone number directly to the VA.
I mean, what's the point of the regulation requiring all of this information that would notify someone that they could get help from the VA if it's enough to inform them that they might be able to get help from the bank or HUD?
Well, I think that the letter that the bank sent invites the borrower to call in and find out what all those options are. And I think that this sort of presupposes that the bank would not have advised the borrower of his ability to contact the VA directly, given the fact that this was a VA loan.
I mean, you don't see a difference between telling the appellant that he can call the bank for help versus he can call the VA for help?
I see a difference in that it's two different entities. I guess the point that the bank is making is that the fact that he would call the bank doesn't necessarily mean that he wouldn't also then have been given the information to directly contact the VA. He had some vehicle to obtain additional information, what his options were, loss mitigation, and most of those things are done, through the bank anyway. I must concede that he was not directed in this correspondence of his right to contact the VA directly, but I guess the position is that this letter would have prompted him or could have prompted him to call the bank, who may have then advised him, you may contact the VA directly, here's some more information.
Thank you, counsel.
Anything further, Ms. Rios?
Yes, I mean, essentially, the bank stands on its position that an affirmance in this case would not necessarily run afoul of DeLong or Palma. To the extent that DeLong holds that the VA regulations are a condition precedent, the bank would suggest that that holding was improper if you take a look at the clear and explicit language of the regulation. Notwithstanding that, the bank did substantially comply with the requirements by advising the borrower of his rights, potential loss mitigation options, both retention and liquidation, provided a plethora of information regarding who to contact and how, and there was no evidence or testimony about prejudice. Essentially, the borrower simply stated that he didn't have the financial means to make the payments due both to his, he had heart surgery, I believe, so he was recovering. And then he also testified that the company he was working for was facing some financial hardship. That coupled with the fact that there was no testimony regarding any prejudice by the lack of specific
And Ms. Rios,
VA
I hate to cut you off, but you're out of time. You're well over time. So thank you.
Thank you.
And Mr. Bowen.
Thank you, Your Honors. Real quickly, there was some discussion on the disclosures, and if I understand opposing counsel, they were arguing that, and I think they argued in their answer brief that they essentially complied with most of the disclosure requirements. They just left out the VA disclosure. And they cite to the statute in their answer brief. It's 38 USD section 36(4) 3050. But there's actually 4 disclosures that they're required to provide. They only provided one of them. The first one is provide the borrower with a toll-free phone number and, if available, an email address. I'll concede that they comply with that. They gave a toll-free number for the bank. The next one, and I'm referring to the default letter. Explain loss mitigation options available to the borrower. There is no discussion whatsoever of loss mitigation options. Just pay this amount or we're foreclosing. And number 3, emphasize that the intent of servicing is to retain home ownership whenever possible. They didn't include that either. And then, of course, the fourth one is that big 2 paragraphs of VA disclosure requirements. So out of 4 disclosure requirements required, they provided 1, which is just to give a toll-free number to the bank. There is no indication anywhere that they ever told this borrower on the phone, which was testified to. My client testified that he contacted the bank several times and no one ever told him of his right to contact the VA, never told him about his loss mitigation options, never told him about all the different things he was required to be disclosed in this VA disclosure. And it's also important to realize
the argument you're making now directed to the prejudice argument made by the appellee. Could you frame it for us?
Yeah, that's more in regards to their substantial compliance, where they're saying that they substantially complied. And so I think that there's no view of the evidence here that you can possibly determine that they substantially complied. Every case that we've ever seen in any appellate court that I've seen where you fail to include any of the disclosures required by a pre-suit notice, it requires dismissal. You've failed. You've completely failed. This isn't substantial compliance. They included 1 out of 4 of these disclosures. And I think by looking at the disclosures that are required by the VA reg, you can tell that the fourth one, that VA, those 2 paragraphs, is probably the most important one, because that gives you the option of contacting the third-party neutral entity that you're not involved with a dispute to tell you what your what your rights and obligations are. And they admit that they didn't include any of that. So I don't think that substantial compliance holds water. Under any case law that I've ever seen, has a court ever allowed them to exclude disclosures and still allow the foreclosure? But also we cited, we cited in our case that it's probably more likely this case should involve strict compliance because it's incorporating statutory conditions precedent. And we cited the distress con case that says, unlike a contractual condition precedent where it's based on statute, it requires strict compliance. And why do I say that in this case? I understand there's an argument that they incorporated into the mortgage, and some banks have said, well, if you incorporate the statute into a mortgage, now it's a contractual condition precedent. But I think that misses the point, because if I can look at I'm going to look at the note here where it incorporates the regulations. It says that, so those regulations are in effect at all times. And anyways, in the rights, obligations, and duties under those regulations. Under federal law, the liability is strict compliance. You're incorporating that liability into the mortgage itself. You can't just incorporate part of the statute, but not the standards that's applied to that statute. The standard would be strict compliance. They incorporate that into the mortgage. There's an argument that I don't even know if I want to touch on it too much. She was kind of, I think it was one opposing counsel was kind of arguing maybe DeLong was decided improperly because the regulations themselves don't create conditions precedent. I think DeLong disposes that issue. But I'd also like to point out the note itself makes it a condition precedent. It's paragraph 12 of the note, which actually incorporates these regulations. It states in there that security interest describes how and under what conditions I may be required to make immediate payment in full. Some of those conditions are described as follow, and those conditions are the regulations that we're talking about here. So the note itself that the parties agreed to states these are conditions. She notes that there's no prejudice because he didn't contact the bank, or he could have contacted the bank. He did contact the bank. He testified that on multiple occasions he's contacted the bank, and no one ever told him about these rights that he had for VA loans. It cited in their answer brief that they sent him 6 loan modification, loss mitigation applications, and never complied with them, never sent anything back. Well, there was no evidence that they sent 6. They didn't introduce 6 documents. They didn't have any testimony that they sent 6 loss mitigation package. They only introduced 1 loss mitigation packet that he said he never received. Now, I'm not saying that they didn't send it. That would be beyond my homeowner's knowledge. He wouldn't know what they did or didn't send. But he can testify that he didn't receive it, and that wasn't rebutted. I don't think anyone's suggesting he was lying in that. And the relevance of that is you can't say that he's ignoring these things, therefore he wouldn't have complied with, he wouldn't have called the VA even when we sent it, because he's not even sending back this loss mitigation application where he didn't receive it. So he wasn't ignoring this. He's tried at every step to get some assistance from the bank, and he was just deprived that opportunity. Had he been able to call VA, this might be a different situation today. Had the bank realized early on in this case, which they could have because it was raised as an affirmative defense, had they realized early on, yeah, you're right, we didn't send these VA disclosures. It's obvious they didn't send the VA disclosures. They're admitting that they didn't send them. The simple solution, rather than putting the homeowner through another 2 years of foreclosure litigation, 2 years of appeal, and all the fees and costs and everything that is associated with that, and racking up, what was once maybe a curable defect, now it's insurmountable. Probably the best solution was to recognize at the time, yeah, we didn't send this notice. Maybe we should do something about that. They didn't do that. Instead, we've been spending the last 2 years, 3 years, however long it's been, litigating this issue. Let me just check my notes really quick to make sure. Oh, and I thought it was also, and I don't know if I already mentioned this, I know I meant to, because I found it pretty striking in this case. I've been involved in a lot of foreclosures, probably 1,500 of them in Brevard County. So I've seen a lot of them where, a bank fails to send a notice or does something improper. It's a technical fault. We get it. Mistakes happen. The banks aren't above it. I'm not above it. I'm sure your honors made mistakes every once in a while. But what's striking about the testimony here is that this is part of their company policy. Their witness testified that she has never seen a VA compliant notice, and that they, on their own, decided they're not going to send the VA disclosures. They're going to send the HUD disclosures because they subjectively believe that's just more user-friendly. It strikes me that they think it's within their capacity to overrule federal regulations, what the VA says are required to disclose to the homeowner to best prevent a foreclosure and the escalation of this debt with their own subjective belief of what they think they should send. To me, that's very striking. I can't see any equitable reason for allowing that to stand or for excusing them from their company policy of not complying with the VA regulations. To me, that seems like it would give carte blanche to any bank to say, we're just going to send what we think we should send, and that should be enough. So I don't see any reason for departing from DeLong. They admit they didn't send it. There is no substantial compliance. which I don't even think substantial compliance complies. He was prejudiced. The very prejudice is that he didn't receive the notice, let him know he can contact the VA. I mean, that prejudice is, I think, evident on its face. There's something I'm missing here, and I apologize 1 second. I think that's it, Your Honors, except for, I think, pursuant to the DeLong case. And I think I cited to another case that, you know, the proper remedy in this case is a dismissal of the underlying foreclosure action. With that, unless Your Honors have any questions for me, I'll rest.
All right. I don't think we have any further questions. So counsel, thank you for your arguments. And at this time, this court is adjourned. Have a good day.
Thank you, Your Honors.
Thank you.